having been allowed by the court to participate in line with the provisions of sections 6 and 9 of the Victims Protection Act, did also address the court on the question of bail bond. At the hearing of the application, a number of the advocates from the side of the prosecution and the victims made submissions at length, and since the prosecution bears the burden of proving existence of compelling reason as to why an accused person should not be released on bail on pending trial in line with the provisions of Article 49, Sub-Article 1H of the Constitution, submissions on the side of the prosecution were made first. I have considered the submissions made by the counsel for the prosecution and for the victims who make their submissions at the hearing of the application. That is Mr. Wood, Mr. Owiti, and Mr. Njue for the prosecution, Mr. Beil, Mr. Biambo, Mr. Mwenda'S, and Ms. Nicholas for the victims. Each made submissions on as to the existence of compelling reason as to why the accused person should not be released on bail on pending trial. At the end of submissions of the said counsel, the defense counsel sought time to make their submissions in response on another day, and this court allocated a date of today, 23rd of October 2023. Today, Dr. Aminwa and Mr. Omari, advocates for the accused persons, have indicated to the court that they do not wish to make submissions and would let the court make a ruling other than the submission that no compelling reason has been presented to the court. The defense also indicated that the accused person filed affidavit today, sworn on 21st of October 2023. Mr. Omari did indicate that he wishes to withdraw the said affidavit. On the face of the said affidavit, there is indication that the same was filed today and served on the prosecution today at 23rd of October 2023 at 11:07 a.m. An affidavit contains statements on oath which, once filed, can only be withdrawn by the deponent of the affidavit on oath, so that an advocate on record cannot be allowed to withdraw statements on oath made from the court. Nonetheless, the said affidavit was improperly placed on record after the prosecution had already concluded their submissions on the application to have the accused person denied bail on Thursday, 19th of October 2023, and being improperly on record, the same is expunged from the record on the basis of that irregularity. For the purposes of clarity, it is important to indicate at the outset that the contents of the said affidavit, having been so expunged, do not therefore form part of what the court has taken into consideration in this ruling. The prosecution and the victims' advocates made quite substantive applications for 3 hours in total, reciting all submissions made in this ruling would have made it quite long, and therefore, with respect, I do not consider it necessary to reproduce the submissions in this ruling, though I will be making reference to the same as I proceed on, and as already indicated, I have considered all the submissions made by all the counsel who addressed the court at the hearing of the application. This court has not considered it necessary to call for filing of a prebail report in this matter, as was sought by the prosecution, as the submissions made are enough to determine the application on its merits in order to avoid unjustifiable delay to the detriment of either party. The main point for determination is whether the prosecution has established the existence of compelling reason or reasons as to why the accused person should not be released on bail or bond pending trial in line with Article 49, Sub-Article 1H of the Constitution of Kenya. On this, I am guided by the bail and bond policy guidelines, which provide at page 25 thereof as follows, and I have reproduced it, and I propose not to read it. The principal consideration in every application for bail or bond pending trial is whether an accused person, if released, would turn up for trial. That position is stated in the case of Twaiba, Hashim, Mukandi, and 3 others versus Republic, 2014 EKLR, where the Honorable Justice Bogoli Musaka J, as he then was, said, I quote, the basic consideration in application of this nature is whether or not the applicants shall avail themselves before the court to take their trial. The provisions of Article 49, Sub-Article 1H of the Constitution of Kenya is to the effect that every accused person or arrested person is entitled to be released on bail or bond pending trial unless there is any compelling reason as to why he or she should not be so released. A key consideration, therefore, is whether the prosecution in this case has established the existence of any compelling reason as to why the accused person herein should not be released on bail or bond pending trial. While dealing with the question of what amounts to compelling reason, the High Court, in the case of Benjamin Njiru Beil versus Republic 2021 EKLR, said as follows, I quote, the Court of Appeal in Michael Juma Oyamo and another versus Republic 2019 EKLR adopted the definition of the phrase compelling reason in the case of Jackson, Malende, and 3 others, criminal case number 53 of 2009, where the learned judge held as follows, quote, the phrase compelling reasons would denote reasons that are forceful and convincing as to make the court feel very strongly that the accused should not be released on bond. Bail should not therefore be denied on flimsy grounds, but on real and cogent grounds that meet the high standards set by the Constitution. Unquote. Submissions were made with regard to specific reasons advanced by the prosecution counsel and by the counsel on record for the victims. I shall therefore proceed to deal with those. The first is whether the accused person is a flight risk. Submissions have been made by the prosecution counsel and the advocates appearing for the victims to the effect that the accused person herein is a flight risk. It has been submitted that the accused person made a statement in the social media that he was to appear at the office of the Directorate of Criminal Investigations at Beil, and that the accused person made the statement on Friday, 13th of October 2023, but failed to appear at the offices of the Directorate of Criminal Investigations until 17th of October 2023. That part of the statement that was made by the accused person and his associate with whom he appeared on social media was that the accused person had intention of going out of the country on sponsorship by the associate to study law, and on the premise of that submission, counsel contended that the accused person is therefore a flight risk. In support of this submission, Mr. Theuri Advocate relied on affidavit sworn on 18 must, as by law required, bear a stamp signed by a commissioner of oaths who commissioned the affidavit to which the particular exhibit is annexed. Rule 9 of the Oaths and Statutory Declarations rules provides as follows, I quote, all exhibits or affidavits shall be securely sealed thereto under the seal of the Commissioner and shall be marked with serial numbers of identification. End of quote. In this case, the document in question does not meet the legal requirement as contained in the said rule, unlike the rest of the annexures to the said affidavit. The same is therefore not properly on record. There was need for evidence of the investigating officer by way of an affidavit that the video clips that were played in court during hearing of the submissions by the advocate for the victim were subjected to analysis at the Cybercrime Unit of the Directorate of Criminal Investigations using appropriate tools to confirm that none of those videos was neither interfered with nor was a product of artificial intelligence. Encyclopedia Britannica says the following regarding artificial intelligence, and I quote, artificial intelligence, the ability of a digital computer or computer-controlled robot to perform tasks commonly associated with intelligent beings. The term is frequently applied to the project of developing systems endowed with intellectual processes, characteristic of humans, such as the ability to reason, discover meaning, generalize, or learn from past experience. End of quote. In my assessment, the video evidence is neither sufficient nor reliable enough to support the submission that the accused person is a flight risk. It would be dangerous to rely on the clip as evidence without a background contextual basis of its existence being laid by way of viva voce evidence and tested. I have gone through the record, and what is clear from the record on the face of the charge sheet is that the accused person, prior to preference of the charge and arraignment of the accused person before the court to take plea, he was out on police cash bail. He was out on cash bail granted by the police, and then he turned up voluntarily to take plea. There is no reason enough for this court to believe that the accused person, if released on bond or bail, is not likely to turn up for his trial. There is no information on record by the investigating officer indicating that the accused person was at any one point summoned to appear before the investigating officer and failed or neglected to do so, and to appear at the time or place as required of him in the summons. One thing that must not be forgotten is that the accused person under Article 50, Sub-Article 2(1)(a) of the Constitution enjoys presumption of innocence throughout the trial. The same provides that, I quote, every accused person has the right to a fair trial, which includes the right, A, to be presumed innocent until the contrary is proved, unquote. Number 2, likelihood of interference with witnesses. The second ground advanced is that the accused person is likely to interfere with witnesses if he is released on bail or bond pending trial. The prosecution submitted that the accused person is likely to interfere with witnesses in this case. The manner in which such an allegation is made should be handled by the court has been explained in two authorities, that is, Panju versus Republic, 1973, East Africa Law Reports at page 282, and Jeffer versus Republic, 1973, East Africa Law Reports at page 39. In the latter mentioned case, it was held as follows, I quote, "Time and again, this court has said that the true test of a bail application is whether the granting of the application would be detrimental to the interest of justice. It is for the prosecution to satisfy the court that this would be so if bail was granted. Dealing with question of tampering with witnesses, Wilson, acting CJ, as he then was, said in Bagwanji, Ukubai, and Republic, 1, Volume 1 of Times Law Reports, at page 43, quote, "The tests laid down in English cases were that there should be a definite allegation of tampering or attempted tampering with witnesses, supported by proof or admitted facts, showing reasonable cause for the belief that such interference with the course of justice was likely to occur if the accused was released. In this case, there was no more than mere assertion by the prosecution that the applicant would interfere with prosecution witnesses if released on bail. There were also fears that he would abscond. There was no evidence whatsoever to support these hypothetical fears." And further quote, "In Republic versus Anthony Karanja Jeru, 2016 EKLR, the High Court said, quote, it has long been recognized that an accused person who interferes with witnesses does not qualify to be granted bail. In Panju versus Republic, the High Court held that where an allegation of interference with witnesses is used as a ground of opposing release on bail, the prosecution must produce evidence. This was the practice under the Independence Constitution of 1963. The requirement to produce evidence to support an allegation of interference with witnesses is, in principle, good law. The reasonability of the witness in his or her testimony before the court, or the very ability of the witness to attend court. The Honorable Justice F.A. Ochieng, in the case of Republic versus Abel Kipro Malel, 2014 EKR, said as follows, I quote, "In the case of Panju versus Republic, 1973 PA at 282, specifically at page 284, the learned judge said, quote, "As for the allegation of interference with witnesses, I would say that it is not substantiated. It should not have been difficult to do this if such allegation has any basis. The investigator could have sworn an affidavit explaining what he had done and who he had contacted and what the results had been so far. Before anyone can say there would be interference with vital witnesses, at least some facts should be led to the court. Otherwise, it is asking the court to speculate. Speculation has no limit, and it is for these reasons that I refrain from taking into consideration matters raised by senior state counsel. From these words, it is crystal clear that in that case, the investigating officer did not swear an affidavit. The court was being asked to conclude that there would be interference on the basis of statements made from the bar." End of quotes. What is clear from these authorities is that any allegation of interference or likelihood of interference with witness or witnesses should be supported by a statement on oath by way of an affidavit sworn by the investigating officer. Submission from the bar without supporting evidence on oath does not suffice. Mere allegation that an accused person is likely to face more charges per se is not a reason also for denial of bail bond pending trial. and that position too is clear from the decision of the above quoted Banju case. Next is association and influence. The next ground raised as a reason why the accused person should not be granted bail or bond pending trial is that the accused person is associated with influential person and is now, subsequent to alleged commission of the alleged offenses, positioning himself in the social media as a brand despite being a fake advocate. I have considered the submissions relating to this point. There is no doubt that as long as freedom of association is enjoyed in a manner that does not interfere with rights and freedoms of another person or others within the confines of the law, it ought not be used as justification for denial of a right, in this case, the right to bail or bond pending trial. An accused person has the right to associate with any person of his choice, including politicians, and it is within discretion of those whom he wishes to associate to decide whether to associate with him or not, guided by their own individual conscience. It would be an absurdity to deny bail to a person on the ground that videos have allegedly been posted on social media depicting the person as an associate of a non-desirable or influential person. Public interest and protection of the accused. It was submitted that the accused person presented himself as an advocate and that it is in the public domain that he alleged to have won 126 cases. Mr. Leuri submitted that while the number of cases which the accused person had handled is not known, there is indication from the accused person's allegations in public domain that he has won 126 cases, and therefore there was at least 126 victims of his being an imposter. And on this premise, the prosecution also submitted that the accused person should be remanded in custody pending trial because of his own safety, because there could be at least 126 people out there looking for him. These two submissions were in support of the contention that it is in the public interest to deny the accused person bail or bond pending trial, and that he should also be denied the same for his own safety. While dealing with the question of public interest, the Honorable Justice Mativo J. had this to say in the case of Republic versus Danfon Kabadi Mwangi 2016 EKLR, and I quote, "There is no denying the fact that liberty of an individual is precious and is to be zealously protected by the Constitution and the courts. Nevertheless, such a protection cannot be absolute in every situation. The valuable right of liberty of an accused person and the interest of the society in general has to be balanced. Liberty of a person accused of an offense would depend upon exigencies of the case. It is possible that in a given situation, the collective interest of the community may outweigh the right of the personal liberty of the individual concerned. Granting bail entails the striking of a balance of proportionality in considering the right of the applicant, who is presumed innocent at this point on the one hand, and the public interest on the other. The cornerstone of the justice system is that no one will be punished without the benefit of due process. Incarceration before trial, when the outcome of the case is yet to be determined, cuts against this principle. The need for bail is to ensure that the accused person will appear for trial and not to corrupt the legal process by absconding. Anything more is excessive and punitive. The general rule, in my view, is for the courts to try to strike a balance between the need for a tie to the jurisdiction and the right to freedom from unnecessary detention of an accused person before conviction, and the need to bear in mind the circumstances surrounding each case. Thus, in determining bail, public good as well as the rights of the accused person should be kept in mind. End of quotes.